understand there's times for mercy, there's times for compassion, Your Honor. But I think undeserved mercy to the guilty is further cruelty to the victims. And they've been through everyone's worst nightmare. 20 plus 20 is 40, and that's really not enough, but that is the maximum allowed under law, and that's what I'm asking you to do on behalf of the Marty family, the Eisenhower family, Christopher Staggs, Boston Carr, and their entire faith community. The one reason all these people, including the Gomez family, are here in this courtroom today is because of what he did, what he chose to do. And it is a tragedy up and down. And so I'm asking you to protect the citizens of Jefferson County from any chance that this could ever happen again from Mr. Gomez. Thank you, Your Honor.
Thank you. I have a question, Mr. Nichols, with regard to deadly weapon finding. I'm looking at the indictment, and it doesn't read that there's a deadly weapon.
Right, I don't believe it does, Your Honor.
Okay. And it's not something I looked into. Is that something I can still find if the indictment doesn't say it?
Yeah, I don't have an answer for that.
Okay. Do y'all know? If it's not, if it's not in the indictment?
The court would have to find, it is permissible without a request, without it being included in the indictment. However, the court would have to point to specific evidence that it was used or intended to be used as a deadly weapon.
Okay.
And I would argue to the court that perhaps, I mean, if there had been other evidence, but there's really no evidence admitted upon which the court could make such a finding, so I would ask the court not to find that. But I will represent to the court as an officer of the court that it is not absolutely required that it be included.
Okay. I really didn't think so. I just wanted to make sure. I would think I guess, Mr. Young, would you disagree with the information that is provided in the pre-sentence report that everyone has agreed that I review, that I could use that as far as, since I've taken judicial notice of that, the letters and everything else, that would be, would you have an objection for me, of me using that if I were in fact to make a finding of a deadly weapon?
Your Honor, I think the court can consider all evidence before the court, and if there is evidence that the court can point to that says this supports the finding of deadly weapon, obviously we can't contest that.
Okay. First, I really do want to thank everybody for being here. We don't have full courtrooms like this. These, just as both of the attorneys said, these are some of the most difficult cases that any judge has to deal with for many reasons, obviously. Mr. Gomez, had you been in, well, I'm not sure that it would matter, but had you been in here and this was your first DWI, there might be some sense of what your attorney was asking for me, which is true. I mean, I have to detach myself from the emotional part, which is, it's impossible, but it's required, and I do the best I can to do that. And there are things about you and your life in the past that are good. There are things that the 3 prior DWIs should have taught you. Your age, you're 52 now, 53 now. You know, it's the 3 DWIs previously, even though they're older, and your age, it's not the establishment's fault. Did they violate the law? Absolutely. You're a grown man. Grown man. Got into a vehicle, and you know from your history, you know from your age, you know probably from telling your own children not to drink and drive, and trying to probably instill that in them, and you did it, and you did this. So at this time, in cause number 24 DCCR 1651, I'm going to find you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. I'm going to sentence you to a term of 20 years in the Institutional Division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. I am basing that on all of the information that's presented in both the pre-sentence report, the attached reports from the officers, in addition to the letters from Mr. Stacks, who unfortunately had to drive up and see this in person, from what they had to use to identify these two precious young lives, that there's no way that there is any doubt that you used your vehicle in a manner capable of causing death, and that you in fact did that. In cause number 24, DCCR 1652, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication, manslaughter with a vehicle. Sentence you to a term of 20 years. There will also be a deadly finding in that case based on the same information and evidence that I used in the previous one. That sentence will run consecutively to cause number 24, DCCR 1651. In cause number 24, DCCR 1653, I'm also going to find that you entered your plea of guilty freely and voluntarily, find sufficient